True and gentlemen, certainly.
Why don't we start?
Yeah.
Why don't we start? My name is Jim Levin. I'm the Associate Director for the Center of the Study of Dispute Resolution. On behalf of my colleague Dennis Crouch, the Center for the Study of Dispute Resolution, the Journal of Dispute Resolution, and the University of Missouri School of Law, I want to thank you and welcome you all here today for this symposium. I especially want to thank the panel members and our keynote today for their participation, not just here in what they're going to say today, but also in their written contributions that will appear in our symposium issue of our Journal of Dispute Resolution that will come out in spring of 2014. I also want to thank Matthew Smith and his firm Turner Boyd for sponsoring the Continental Breakfast this morning, and I want to also thank Kevin Noonan and Patent Docs for sponsoring the reception that we're going to have at 2:30 this afternoon. Patent Docs, as you all know, is the other great IP blog. There's two of them. One of the two IP blogs that matter. Should I put it that way? No, I'm just kidding. So about 3 weeks ago, I was reading the Sunday New York Times, and in the magazine section, they had a short article. They have a little section called "Who Made That?" And this particular day, it was about the pencil. And it gave a brief history of the pencil, and it talked about how people figured out there was graphite and they made marks on paper, and you could take rubber and remove those remarks and so forth. And everything was well and good. In 1858, a gentleman named Hyman Lipman decided that it'd be more efficient to take the rubber and put it on top of the pencil. And I meant to bring a prop here, but I didn't. And have what we commonly know as a pencil, graphite at the bottom, the eraser at the top, and thought it was a great idea. Filed for a patent. It was approved. And in 1862, 4 years later, he sold the patent to a gentleman named Joseph Reckendorfer for $100,000. 1862, $100,000. That's $2 million in today's dollars. Mr. Reckendorfer was going to produce and market this pencil and become rich and famous. Great idea, except other people had the same idea. And some other people started producing those types of pencils. And a patent fight went to court. And in 1875, the United States Supreme Court ruled the patent invalid because the invention was a mere combination of two known technologies. I'm not sure whatever happened to Mr. Reckendorfer, but by the mid-1920s, almost every pencil manufactured in the U.S. had the graphite on the bottom, the eraser on top. As a side, I've been told that in Europe, that model never caught on. People still have pencil and eraser, and I'm not sure why that is. If anyone has any ideas, I'd love to hear. In my more cynical days, I think it's because the Europeans think they're always right and we're always wrong. We need the erasers, they don't. I don't know. But anyway, as poor Mr. Reckendorfer learned, patent law is about ownership of ideas, and whenever we think about ownership, whether it be intellectual property, real property, we can assume there'll be conflict. And that's been true for as long as we've been around. As I was looking into this, I found that there are at least some patent references that date back 2,500 years. In 500 BC, there were some city-states in ancient Greece that had some patent-like codes in their laws. In Europe, there are references to patent in the 13th and 14th century. A Venetian statute of 1474 provided that inventive devices had to be reported to the Republic once in practice if the inventor wanted to obtain 10 years of protection. So that's 1474. England, France, Italy, other countries in Europe followed suit. The idea of patent and protecting intellectual property extended to the framers of our Constitution, as you all know. 220-something years ago, when they were drafting the Constitution, they put in Article 1, Section 8, Clause 8, which granted Congress the authority to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So that's in the Constitution. And imagine what this country would be like if we didn't have such protections. And also imagine how things have changed so dramatically, not just from back then, but just in recent years. Just last year, there were 600,000 patent applications filed with the Patent and Trademark Office. 250,000 patents were issued. And that's not even including the tens of thousands of patents that were bought, sold, licensed, and so forth. With the increase in patents issued, there's been a dramatic upswing in lawsuits. Last year alone, there were 5,000 cases filed with federal courts, which was remarkably higher than in the most of the last 10, 12 years. It's been around 3,000. Last year there were 5,000. And as all of you know, the cost of defending or attacking a patent is extremely expensive, in the millions and millions of dollars easily in many cases. And that's just the litigation costs. That's not even talking about social costs of developing and marketing and defending or attacking the validity of a patent. So lots of conflicts out there, and with these types of numbers we need to figure out how to find better, more efficient ways to handle these disputes, and that's what this symposium is all about. And it's kind of a natural for it to be here because this law school has been devoted to the ideas of dispute resolution for quite some time. The Center for the Study of Dispute Resolution began in 1984, 29 years ago. Which in most times, at least for me, when I went to law school, we didn't talk about those types of things. So 29 years ago, we started the center, and it was the first center of its kind at a law school. Our Journal of Dispute Resolution was the first journal that dealt specifically with dispute resolution issues. 13 years ago, in 2000, we started the country's first LLM program, Masters of Law program in dispute resolution. We've had currently and in the past, lots of faculty. Their scholarship has changed the way that we think about and practice dispute resolution techniques like arbitration and mediation. And we're also very well known for innovative teaching of dispute resolution to our students. So that's our center, and that's why I think it's natural for us to be here today. In the coming year, we're actually going to have a new center that Dean Myers is going to talk about in just a minute, focusing on intellectual property, innovation, and entrepreneurship. And as we think about the new center and our existing center, this symposium is a perfect intersection of those type concepts, and that's why we're here today. So the layout for today, and I hope you all have your program, we're going to have a session that will start in just a few minutes, focusing on with kind of an industry focus. We'll be looking at smartphones and pharmaceutical type issues that are common in today's world. We will take a 5-minute break after that, kind of a stretching break. I hope you all stay at your seats. And then we'll have our second session dealing with resolving disputes before the U.S. Patent and Trademark Office, looking at alternatives and unique ways to do that. We'll then have a 15-minute break before we have our keynote speaker. Our keynote speaker is Greg Gorder, founder and vice chair of Intellectual Ventures. As you know, Intellectual Ventures has they have far more patents, own more patents than almost anyone in the world. They have more than 40,000 IP assets. They have a reputation for aggressively protecting those patents, but they also have an amazing record of staying out of the litigation process and defending that. And that's what we're going to hear about today. We're going to have a lunch. We're going to break for lunch. There are some restaurants in walking distance, and we have a list of restaurants that you can go to and get back in time for our final session, which will deal with transparency. As we talk about resolving disputes, both in public and private forums, there's a demand, a cry for confidentiality and so forth, but there's also the balance we need with the public's right to know. And that's what we're going to explore in our last session. And that should end about 2:30. At 2:30, we do have a reception that you're all invited to, sponsored by patent docs. And the reception is actually not going to be in this building. It's going to be in the Alumni Center, which is one block there. We're doing it there because we can serve wine and hors d'oeuvres there, so they're all invited. And that will be 2:30 to whenever, 3:30 or 4. So that's sort of our program today. Again, before I turn it over to Dean Meyer, I want to thank the participants for being here. I want to thank all of you who have traveled here to Columbia to be part of this symposium. I want to thank, of course, Dean Meyer for his support in putting this together. We also have an amazing, amazing staff here at the law school and who have helped us put this together. I especially want to thank Laura Coleman, Karen Nealon, and Casey Baker for their help in making this happen. And last and certainly not least, we have a wonderful Journal of Dispute Resolution, student-run. Jessica Coghill and Rachel Hirschberg, editor-in-chief and associate editor-in-chief, have been instrumental in us being here today, and I really, really want to thank them and their staff for the work they've done in putting this together, and also the work they're going to do in putting the symposium issue together for the spring. So with that, I want to turn this over to Dean Meyer.
Well, thank you, Jim, and welcome to the University of Missouri School of Law. Thank you all for coming this morning. I think we have a great conference and a great set of speakers. And as Jim mentioned, I think it's very opportune that this symposium focuses on the intersection between dispute resolution and intellectual property, two areas of law that in 1984, when I was in law school, were not areas that a lot of people focused on, and today both play much more prominent roles in our legal system and in the economy as a whole. And so it's very appropriate that we have this conference today. Also, as Jim mentioned, my hope is that within the next year we will be announcing the establishment of a new center of excellence here at the law school focused on intellectual property innovation and entrepreneurship. I think that will nicely complement our existing strength in the dispute resolution area and hopefully build our national reputation and our programming in this widely expanding area of law and practice. And I just wanted to share with you for maybe a moment an idea of what this center might look like. Of course, one of the things the center would do would be to put on conferences and symposia like the one we have today. My hope is that we can draw faculty to build on our existing strength in the intellectual property area, expand our course offerings, continuing legal education programs, expand our student body in the area of intellectual property by offering scholarships to people who have a background that might be suited to a future career in the intellectual property area. And the last piece of it, and one that I find particularly exciting, is the establishment of a startup center, essentially a clinic that would enable small businesses, university, technology developers, and others in the community and the region to build their companies, protect their intellectual property, and develop their economic initiatives in the future. So my hope is that a startup clinic can be part of this and that it will assist our law students as well in developing their skills in client representation and practice. So there are a lot of exciting things going on at the law school, and I'm particularly pleased with the conference we have today. I too want to thank Turner Boyd and Patent Docs for their support. We can't do these sorts of events without the generosity of donors like both these entities. And I want to thank the organizers, Dennis Crouch and Jim Levin. If we could have a round of applause for them. I hope you enjoy the conference, and thank you.
Good morning, I'm Kevin Noonan. You gonna introduce me? Okay.
This is the awkward part. Now I'm going to introduce Dean Myers, who was just
Yeah, I was gonna
speaking.
say.
And he's going to introduce our speaker.
Okay.
Not the right order, but anyway, I do want to introduce Dean Myers. Gary Myers is Dean and Earl F. Nelson Professor of Law at this law school. He received his Juris Doctor with honors from Duke. and graduated summa cum laude with a bachelor's degree in economics from NYU. He earned an MA in economics from Duke Graduate School. After graduate school, he clerked for the U.S. Court of Appeals for the 11th Circuit in Jacksonville, Florida. He practiced complex commercial litigation with the Atlanta law firm of Powell, Goldstein, Fraser, and Murphy, which has since merged with Brian Cave. He's a longtime member. He had been a longtime member of the faculty at the University of Mississippi before we stole him away last year and to be our dean at this law school. He's an elected member of the American Law Institute, member of the American Law and Economics Association, and the American Intellectual Property Law Association. He's an author and co-author of a series of books on intellectual property, and has authored many journal articles that appeared in the top journals. So with that, I want to introduce Dean Gary Myers.
Thanks again, Jim. And this is the last time you're going to see me up here anyway. I want to introduce our first two panelists. This is a great combination of two people who have a tremendous background and are going to talk about some very specific industry issues related to patent law. Our two speakers are Kevin Noonan, who is a partner in the firm of McDonnell, Boehnen in Chicago. He is the author of the Patent Docs blog and therefore one of our sponsors today. Thank you again. That blog focuses on biotechnology and pharmaceutical patents. Kevin teaches intellectual property at a number of Chicago law schools and is a frequent speaker and media consultant on intellectual property issues. He received his PhD in molecular biology from Princeton University and his law degree from John Marshall Law School. Our second speaker is Jorge Contreras. George is a professor at American University, Washington College of Law, where his research focuses on intellectual property, innovation, and standard-setting organizations. He has been director of the Intellectual Property Center at American University, so I hope to pick his brain later about how you do that. And he's also been a partner at the Washington, D.C. firm of Wilmer Hale. He received his bachelor's degree with a joint major in English and electrical engineering, which is a combination that I find very intriguing. From Rice University, certainly a broad undergraduate education. And his law degree is from Harvard Law School. Kevin will be focusing primarily on the biotech area, and George will be focused on telecommunications, and my job will be to keep time. So, thank you very much.
Thanks, Dean. As I was saying, I'm Kevin Noonan, and what I'm going to do is give you a couple of minutes at a very 30,000-foot level about dispute resolution, and we're going to jump into the specific areas we're talking about. When I was a biologist, one of the characteristics of living things were irritability, and human beings are good at that, and that creates disputes, and especially whether it's a pencil or a biotechnology invention. Then there's a lot more at stake maybe now, more pencils, but more money for the biotech invention. And so you get lots of disputes. Patents are kind of like that unseen celestial object that you can only detect by its effect on other things. It has this effect on the law that every time a patent's involved, things get a little bit, maybe strange is too strong, or a little bit different. The Federal Circuit spent 30 years delineating those differences. The Supreme Court spent 10 years trying to change that, rewrite that, but that's another topic for another day. But the problem is that if you read even as recently as the Chief Justice's dissent in the activist case, which I'll talk about a little bit, the law set up to encourage people to settle disputes because for judicial economy, for costs, etc. And the idea that two independent actors can figure out without government interference what they should do to settle disputes between them. Patents change that. And patents change them because, for one, there's a belief that a patent can give one side a disproportionate strength in any negotiation. And also, secondly, because of the public interest that patents have, there's a belief that we have to be careful. And as the in the 19th century case that was referenced before shows, the Supreme Court has always been very concerned about granting the patent monopoly, they're fans of that word, to people inappropriately. for the belief that it will harm innovation, and really for the belief that it will exceed Congress's ability to grant patents, which is to promote progress. So if a patent inhibits progress, Congress shouldn't have granted it, or the patent office through Congress's authority shouldn't have granted it in the first place. The way that patents have been limited in this sense is if a patent was tried to be extended in its time. So some famous cases about ways that patents are licensed and ways they can't be licensed. If the patentee will get royalties after the patent's expired, that's generally frowned upon, even though no less a luminary than Judge Posner of the Seventh Circuit has said the Supreme Court is wrong about that, but they haven't changed. And also the scope of the patent. If a patent is extended to require payments for things that don't fall within the scope of the patent, and these are famous cases of tying and that sort of thing that we're all aware of. So where it comes up here is, and of course the other thing is fraud. Walker process fraud, obtaining patents through fraud. So what we're going to talk about today is in two different areas, the way that the strength of patents and the power of patents that on the one case, and I think George will talk about, in the standard setting area, where you have patents that influence technologies that we need to have our cell phones talk to one another, and back in the day when it was faxes, and have those talk to one another, and there are standards that the machines that do that need to meet, and so you have the interconnectedness that gives us the world that we have today. I was telling George that this is the best invention for people with Y chromosomes, because you don't have to ask directions, but you can still find out where you need to go. So I think that to live in this world, we have to have standards for that, and we'll talk about that. But I'll talk about, in the Hatch-Waxman context in generic drugs, how the presence of patents has made at least the most recent 5 members of the Supreme Court decide that, in fact, it's not necessarily a good idea to let those sorts of disputes be settled. And there, the interested party is, as it typically is in these cases, the public. And so with that, and very brief Cook's tour of the ideas we're going to talk about, I'll let George tell you about standard setting.
Okay, great. Thanks very much for the introduction, and Dean Myers. Well, thanks for having us here. This is really a thrill and a privilege to be at this conference. So as Kevin mentioned, I will be talking about technical standards, and primarily the ones that relate to the telecommunications industry. Although there are other industries that are greatly affected by standards. These include names that we've heard. They're widely used: Wi-Fi, USB, Bluetooth, HTTP, right? The standards that make the internet work, that make telecommunications work, that allow our computers to communicate and interoperate with each other. These standards are developed typically by groups of industry participants, market participants that get together. They're competitors, but they're allowed under the antitrust laws and by the antitrust regulators to collaborate to create these standards so that products that each of them make can communicate with each other. There are lots of economic benefits to the market that arise from having that kind of widespread interoperability. So where do patents come in? Well, of course, like any technology, the technologies that are interoperable, that are made interoperable by these standards, can be patented. And they are patented in large numbers. So you've probably heard the statistic that RPX has tossed around that the average smartphone is covered by 250,000 different patents. May or may not be verifiable, but one thing that we can be sure about is the number of patents that cover, or that are declared to cover, these different industry standards. So the 2G and 3G wireless telephony standards, previous generations that have made our phones work, the standards bodies that created them require participants to declare the number of patents that they have and to declare the specific patents so that the world knows what they are. And there are thousands of patents declared for each of these standards, between 4,000 and 7,000 patents declared on each of 2G and 3G standards like GSM and its successors that we all know of. So there are lots of patents out there. Patents, as mentioned, give a certain monopoly power to the patent holder. You wouldn't want to have a cell phone that then you couldn't use because the patent holder wasn't willing to grant everybody the right to operate under the patent. So the standards bodies that create these standards impose requirements on their participants. And one of those requirements that's gotten a lot of press lately is a requirement that if you participate in the standards body and have patents that cover the standard or potentially cover the standard, then you agree to license your patents to anybody who wants to use them to implement the standard on terms that are fair, reasonable, and non-discriminatory. It's called FRAND, right? Sometimes the F is dropped into something called GRAND. They pretty much mean the same thing. But essentially, FRAND and GRAND mean many things, but the one that people focus on the most these days is that the royalty rate that you charge for the patents needs to be within some reasonable range. And what that reasonable range is tough to figure out. Courts have been starting to do that because there have been some disputes, right? As you can imagine, FRAND is a fairly loose and not particularly well specified term. The standards bodies themselves take great pains to say, we require that you license these patents on FRAND terms, but we're not going to say what FRAND means. That's for the industry participants to figure out by themselves. And in most cases, industry participants do figure it out for themselves and they enter into license agreements with each other, but in some cases that hasn't worked. And so we do have disputes, and it's a lot of the big name headline litigation that we hear about in the news today. So companies like Apple and Samsung, Motorola, Microsoft, InterDigital a few years ago, Qualcomm, Broadcom, Rambus, all of these cases and these big industry players were to some degree fighting about whether each other had lived up to their FRAND commitments and what the FRAND royalty rates ought to be. As I said, courts have started to get into the role of determining what these FRAND commitments are, but that's a difficult thing to do. And Microsoft and Motorola, in April, the federal district court judge in Seattle had to issue a 208-page opinion going through in very much detail every patent and every standard and evaluating and weighing comparables and figuring out what Motorola's reasonable royalty rate would be for two pretty common industry standards. Okay, that's the royalty determination piece. So, as Kevin alluded to, one of the powers that a patent holder has by virtue of having his patent is stopping infringers from infringing the patent, right? And you do that through injunctive relief, seeking injunctive relief in the courts. And the question of whether you can and should, and under what circumstances you can seek injunctive relief if you have a FRAND commitment is one that's been getting a lot of attention lately as well. Why is there a debate about this, right? Patent holders often can get injunctions. You go to district court, you are mindful of the Supreme Court's eBay versus Merck Exchange case, which sets out the 4 equitable factors that need to be satisfied in order to get injunctive relief, and you make your arguments. If you're a practicing entity like an Apple, a Microsoft, a Samsung, you typically still can get injunctive relief these days. But the calculus is a little bit different when standards essential patents are involved because of the FRAND commitment. And the argument that's made is, well, why should you, patent holder, be entitled to an injunction? You have to show irreparable harm. You have to show that a monetary remedy would be insufficient to compensate you for the infringement. And if you've committed to the world that you're willing to take a royalty on terms that are fair, reasonable, and non-discriminatory, whatever that may mean, then at least you've told us that there's a monetary remedy that will satisfy you. So we shouldn't give you injunctive relief, right? And there are lots and lots of arguments around that question. All of the regulatory agencies, from the ITC to the U.S. Trade Representative to the usual suspects, the Department of Justice, Federal Trade Commission, Patent and Trademark Office, have all jumped into this debate. And there are lots of twists and turns to it. But suffice it to say, for purposes of our discussion this morning, that it is a difficult and fraught question as to whether a patent holder can seek injunctive relief in the face of a FRAND commitment on standards essential patents that it's already made. So, Federal Trade Commission feels especially strongly about this issue, and last year, in connection with other investigations that related to Google's search technology, they also initiated an investigation of Google, and principally Google's Motorola subsidiary, right, which Google acquired in 2012, about just this thing, whether it was permissible under Section 5 of the FTC Act for Motorola to seek injunctions against other parties when it had made FRAND commitments to them. And to make a long story short, that investigation was settled in connection with the settlement of all of the Google search investigations as well. And the FTC Google settlement, which was first issued in preliminary form in January of this year, it only became final in about June, after quite a lot of public commentary and discussion, says the following. Okay, we investigated Google, or the FTC investigated Google Motorola for a violation of Section 5 of the FTC Act. The FTC thinks that asserting or seeking injunctive relief if you have a FRAND commitment would violate Section 5, but it would not be a violation of Section 5 if Motorola and Google followed some procedures, right? And this is where we get into the topic of today's conference, which is arbitration and ADR, right? So the order specifically says, it creates a safe harbor, and says that a patent holder who has a FRAND commitment must offer to arbitrate. It says a lot of things, but it also says that a patent holder must offer to arbitrate what the FRAND royalty rate would be before it seeks injunctive relief. And it has to go through either an arbitration or negotiation or even litigation for at least 6 months before it can seek injunctive relief against a potential licensee who might have been willing to enter into a license on FRAND terms, right? So here we have the Federal Trade Commission affirmatively saying arbitration is a good thing. We should encourage it, and it creates something of a safe harbor for companies. You have to do it before you can seek injunctive relief against infringers of your patents if they're standards essential patents. Other agencies have jumped on this bandwagon. Representatives, high-level representatives of the Department of Justice have also recommended that standards organizations, right, the SDOs themselves, create procedures so that their members can arbitrate FRAND disputes rather than going to court, right? The 200-plus page opinion in Microsoft and Motorola is very well done, but it cost the parties millions of dollars to get there. The litigation's been going on since 2010. So we have years and years and millions of dollars at stake that Microsoft and Motorola can afford, but not everybody can afford, right? So the Department of Justice at least views arbitration as an alternative that could create some efficiency, or at least get rid of some of the market inefficiency that some of this litigation has created. Okay, so that leaves us with arbitration as a potential route toward resolving FRAND disputes, and there's been a huge amount of interest as a result, both in the practice community, the scholarly community, among the regulators, and among arbitrators and dispute resolution professionals. WIPO has started to create guidelines for arbitrating FRAND disputes. Other arbitration experts have jumped into the fray because everybody sees this is becoming sort of a growth industry for arbitration and arbitration tribunals. So one of the things that I do in addition to my teaching duties, I co-chair an ABA committee that relates to technical standards. And our committee got together with an ABA committee that deals with ADR, and we realized, look, you know, we know a lot about patents and technical standards. We don't know a heck of a lot about arbitration. Because patent disputes are typically not arbitrated, right? Very long and interesting history described in the paper that'll be in the journal. You know, the Federal Arbitration Act, enacted in 1925, says arbitration is great, it's a national priority. But for the longest time, disputes about patent validity and infringement could not be arbitrated under the FAA. The judicial interpretation was that these things were, for public policy reasons, not within the scope of the Arbitration Act. It wasn't until the Patent Act amendments in 1982 that we finally amended the law to say that, okay, you can actually arbitrate patent disputes. But there's a presumption against arbitration of patent infringement and validity disputes, and very few of them are arbitrated. That has the potential to change now in a big way. So the paper that we produced for this symposium and for the journal issue tries for the first time to really lay out in a systematic way, what are the issues that arbitrators are going to have to think about, and what are the issues that standards people are going to have to think about when they start to bring these FRAND issues to arbitration, which hasn't been done before. And when you think about it and delve into it and get these two groups of people who never really talk to each other together, there are a number of interesting things that come out. So I'll just mention a few of them, but as I said, the paper talks about quite a laundry list of them. So the first interesting issue is what issues should be arbitrated? Number one, you have the issue of what is the fringe royalty rate, right? That's important. That's an obvious issue that everybody wants to know. But there are lots of ancillary issues that go along with that, right? Can you figure out what the fringe rate is if you don't know whether all of the patents being asserted are valid? There have been studies done on the telecom standards, the 2G, 3G standards that conclude, and these studies have been contested, but these studies conclude that the rate of accuracy in declaring standards essential patents is something like 28%. That meaning that only 28% of the patents that are actually claimed to be essential by the patent holders are, in the estimation of these third-party researchers, actually essential to. And there are lots of reasons that that number is so low, I won't get into, but are they actually essential? Essentiality is a potential issue to be arbitrated. And then validity. Even if they're essential, the patents might not be valid for all the reasons that we know about. And they might not be infringed. You might think, well, if I comply with the standard, then of course I have to infringe all the patents that cover the standard, right? But again, it's complicated. That's not always the case. Some standards have optional components, and that's another thing. Then there's a whole raft of other ancillary issues. Breach of contract, which is the main issue in the cases between Apple and Motorola and Microsoft and Motorola. They're not infringement cases yet, they're breach of contract cases. Antitrust, common law fraud, a whole raft of other issues that are potentially there, they're brought up in the suits. Should they be arbitrated, or should they just go to district court in parallel proceedings? Second big question, the preclusive effect of the arbitration. One of the reasons that the regulators have said that, well, we want to make the system more efficient because it takes so much time and money to get to these fringe rates in judicial proceedings. Well, is arbitration going to help if the arbitration proceedings are A, confidential, which they usually are, and B, have no preclusive effect on non-parties? So Kevin and I are in litigation, we fight about the fringe rate, we go to arbitration, we come out with it, 1%. That's my fringe rate. Does that have any bearing at all on the case when Dennis is infringing that same patent? Well, typically no in arbitration. But if we're thinking about this at a systemic level, you might think, well, maybe there should be at least some informative value that our arbitration has on the subsequent arbitration. Confidentiality is, of course, a huge question. Should the results remain confidential, as they usually are in arbitration, or should they be made public? There is a paper that's out by Mark Lemley and Carl Shapiro at Stanford and Berkeley, respectively, a very good paper about the use of arbitration to resolve these disputes. And they propose that baseball arbitration be used. And I don't know if this will be discussed in future sessions at the conference, but for those who don't know, baseball arbitration is a special variant of arbitration. In normal arbitration, conventional arbitration, the arbitrator acts like a judge. And just as in Microsoft and Motorola, each party comes forward with its theory of liability, its damages experts, puts forward a number for royalty, and then the judge will look at those, and as happened in Seattle, he says, well, neither of you are right. Here's the right answer. I will figure it out for you. Interestingly, in the Seattle case, the judge said, okay, Microsoft, your theory is just totally wrong here. We're going to use Motorola's theory, but then came up with a royalty rate that was far, far closer to Microsoft's proposal than Motorola's. So they each kind of won in that respect. Baseball arbitration, you don't do that. Baseball arbitration comes out of Major League Baseball player salary negotiations. Management comes up with a salary number, they put it in an envelope, give it to the arbitrator. Player comes up with a number, gives it to the arbitrator. The arbitrator has only two choices to make, either management's number or the player's number. Theory is that will bring the parties closer together, right? It'll force them to be more reasonable if you have something that's way out in left field, so to speak. You're right field, you're not. Left field, you're less likely to have the arbitrator pick it, right? But it's a 1-2 choice. You flip a coin. There's no underlying rationale, has less preclusive informative effect. Nevertheless, it will resolve the disputes more quickly, right? So there are lots of pros and cons to this methodology. Not clear what's going to happen. Baseball arbitration is used very, very seldom in commercial disputes. As we mentioned in the picture, if you look at Gary Bourne's 1,000-page handbook on international commercial arbitration, baseball arbitration, it's not even in the index. It does not appear. It's very rare outside of labor disputes. So could be something interesting to explore for the future. We have a big laundry list of other issues in one of the appendices to the paper, and I won't go into them all. Happy to take questions, and with that, turn it over back to my co-panelist, Kevin.
Thanks. Totally different in the pharma area for a lot of reasons. Remember the obsolescence timelines, even for this, are fairly short compared to pharma. The amount of regulation, not through standard setting, but through the FDA, is much greater. But it all comes down, at the end of the day, to what's important now is the Hatch-Waxman. Because in 1984, Congress decided, reasonably, that a Supreme Court case, Roche v. Boehner, was harming the development of the generics industry because the case said that it would be an infringement to do the sorts of work a generic would have to do to get ready to enter the market once a patent expired owned by a pharmaceutical company, because you have to make, use, etc., not sell, but make and use the pharmaceutical to make a generic product. And Congress said, well, that clearly means we're giving 2 to 3 to 5 years of extra exclusivity to the branded pharmaceutical maker who owns the patents, and let's figure out a way to prevent that. So it did two things. One, it made a safe harbor so that you could do those sorts of things, but because Congress is Congress, it said, well, let's also provide an incentive to go after those bad patents. And sort of that is the boogeyman of this area. There's always a bad patent out there. I think that the IPO had a survey that was reported a couple of years ago that said, has the quality of patents gone down? And everybody said yes. And I talked to the director. I said, why don't you ask them, have the standards of your patents gone down in recent years? Because everybody thinks everybody else's patents have gone down. But anyway, so the bad patent in pharma, or the way to get after them, was as following. First, the carrot was 180-day exclusivity to any generic. The first filer of an abbreviated new drug application, which is essentially what a generic files to get FDA approval. However, the stick, or the countervail to that, is that the very act of filing an ANDA would be a statutory act of infringement. And if the brand, the drug company, filed suit within a certain amount of time, 45 days of getting notice of the ANDA, then the FDA would grant a 30-month stay to approving the ANDA. So the generic now was prohibited not by an injunction, but by regulatory agency action from coming on the market, just because the agency wouldn't approve in that amount of time. And the lawsuit would go forward, and it would be over patents that were listed in the FDA in something called the Orange Book, that what became known mostly because its cover was orange back in the days when you didn't have things online, when you actually had books. And so that was where the Donnybrook and the dispute would be joined. We've had about 30 years almost of the Hatch-Waxman litigation, and there have been papers written, not by me, by others, that say it's in balance. Generics come to market, absolutely, but the amount of money that's been spent in litigation is astronomical, and for some reason I think that's a bad thing. But the fact of the matter is that I could make an argument that paying lawyers, as beneficial as that is to some of us, isn't necessarily the best way to spend the kind of money that, as my hair gets grayer, I wish people would spend on developing drugs. So because of that cost, because it is patent litigation, and we talked about how expensive it is, and it's high-stakes patent litigation because even though the standard settings, when you get to lots and lots of cell phones, can make a lot of money, blockbuster drugs can be billions of dollars a year in sales, so clearly high stakes. Because of that, and because of the fact that one half of the equation is a generic drug company, which especially at the beginning didn't have a great deal of money to do this, there's a certain amount of pressure to settle these cases. And from the branded side, one of the reasons is that if you think about traditional litigation, both the accused infringer and the patentee come to the table with different things at risk, but both are at risk. And the patentee, the risk is market share, obviously, but also their patent and the validity of their patent. And if it's ruled invalid, not only do they lose the market share to the challenger, but to all challengers who will then come. But secondly, typically the accused infringer is usually on the market. And so they have articles in the stream of commerce, they have to risk an injunction, they risk royalties and past royalties and willfulness and all that. Well, as I said, filing an ANDA is a statutory act of infringement. And so if the generic loses, the only thing they lose is the ability to enter the market before the patents expire. So even though there's a certain amount of investment cost that they put at risk to do that, and certainly they want the 180-day exclusivity, which is the jackpot for them, the fact of the matter is that you have switched in some ways the risk calculus that's involved in these sorts of disputes. To give you a real world example, we had a case that recently settled on a drug that the most of the damages that we were trying to get, which were quite substantial, came in that 180-day period. Because if, for example, the pill that the branded was selling for $1, if that was the number, the 180-day exclusivity generic was selling it for 98 cents. Why? Because even that much of a small amount in reduction, when you are in a big formulary, a big company, a hospital, you can still make that margin. The government can make that margin even at a 2 or 5% reduction. So lots of money to be made. Probably around the mid-90s and starting into this century, you had branded drug companies and generics settling. And typically, and also something that's an anomaly, it was the patentee that was paying the generic to stay off the market. And the quid pro quo many times was that the branded drug company was allowing the generic drug company to enter the market earlier than they would have if they had lost the litigation and had to wait until the patents expired, but sooner than earlier than if they had lost and later than if they had won. So it was a compromise, as with most of these things. You did get generic drugs entering the market earlier than they would have had they won, but not as early as had they lost, but not as early as had they won. And there was usually, in some cases, there was lots of money here, hundreds of millions of dollars in some instances. Well, the FTC went on what could only be called a crusade against this practice. And some of their reports that they really read like the posters for Reefer Madness from the 30s, that this was the worst thing that could ever happen to the American consumer. And they had a point at some level. And they took that point and they went into litigation in it. And the problem is, although the first case, in the Sixth Circuit, the Cardiazem case, the court found sufficient shenanigans that they ruled in favor of invalidating that settlement agreement. Every case thereafter, and maybe the parties got more savvy after this case, when courts looked at it, the argument was, if you look at on balance, if you look at the benefits and the risks and what these were pro-competitive, or at least not anti-competitive, agreements, that generic drugs were entering the market sooner than they were otherwise, and that the numbers that were being bandied about were not unreasonable given the markets and how much money was at stake in litigation. Part of the basis for this in many of the courts was that the patentee had not done anything to do all those things I talked about at the beginning to exceed the scope of the patent, the test was ultimately called the scope of the patent test, developed by the 11th Circuit. And if that was the case, then there wasn't anything per se illegal, which was the FTC's position. These agreements were per se illegal restraints on trade. And that position softened, but not before in 2003, the Congress passed the Medicaid Modernization Act, and as part of that act, every one of these settlements had to be filed with the FTC within sort of 10 days when it was finalized. And so the FTC started getting all of these settlements and having the power to review them, and having the power to bring actions both at the commission and in the district courts, and in supporting, as amicus, or maybe even more so, consumer groups that started to bring, not only consumers, but the drug wholesalers and retailers. And so you started to get these in-re tamoxifen litigations, which were these consolidations of many, many suits that had been brought in different states against both the drug company and the generic. And of course, the funny thing was that at that point, the generic had switched sides, and they were perfectly on board with the patent being fine, and that this was all the things that they did say and no longer. And that also raised a certain number of hackles and a certain number of raised eyebrows. But I will say, having looked at all these cases, that both at the district court and the appellate court level, the courts did a very good job of casting the jaded eye at these things and not just taking everything at face value and really trying very hard to determine whether there was any shenanigans going on. And in all those cases, they determined that it was not. Now, the one chink in the armor of the decision is part of that was a presumption that the patent was valid. And in cases, if there had been cases, or if in these cases, if the patent had a serious inequitable conduct or Walker process fraud charge, we might have had a different issue, but I don't think those cases ultimately settled. Those are the ones, frankly, that are the red meat to generics, and they're not going to settle those cases. There's a good chance they're going to, if I want to claim unenforceable, the whole patent falls, as you know. So in the cases that were looked at, even though you had quite a bit of litigation in this area, the courts decided no, these agreements were okay. And the FTC has been asking the Supreme Court to take a case forever, but realized that it wasn't going to really happen until they got a circuit split. And in a year or so ago, in the Third Circuit, in the Cater case, they had such a circuit split. That court found the scope of the patent test was not the right test. The patent couldn't be presumed valid. That these were presumptively illegal agreements and were capable of being invalidated in what was called a quick look rule of reason, which basically is not exactly per se, but pretty close. A pretty strong presumption that they were illegal. And everybody at that point asked the Supreme Court to please take the case, because the Third Circuit's where a lot of the pharma companies are, and the FTC made a statement that if the Supreme Court didn't grant cert, they would bring every case in the Third Circuit. And that would be the law. So the Supreme Court did grant cert. Not in the Cater case, but in another case in the 11th Circuit, which was solely a case brought by the FTC as opposed to a case brought by private parties. And that case was initially FTC versus Watson. It became FTC versus Activist as the case was reported. And just in its last term, the Supreme Court decided, in a split the baby sort of way, but not exactly, that in fact these there'd be factors that had to be looked at by the rule of reason, not presumptively illegal, but if you look and read the case carefully, they didn't use the words presumptively illegal, but the factors they instructed courts to use, which were the size of the settlement, whether there were any other ways that the parties could have settled, whether the parties had, the patentee had market power, all things that you scratch your head and say, of course they have market power, they have FDA regulation and a patent. But the decision by Justice Breyer that reads very reasonably, this is something that you can't, it's his Goldilocks view of patent law. You know, you have to have the right balance between patent law and antitrust law, so you can't just presume that they're valid, but you have to apply antitrust reasoning as well. And that's fine, except according to Justice Breyer, you don't have to look at whether the patent is valid in the first place. And so the way the law is now, and I'll talk about the Chief Justice's dissent, is that if you challenge this sort of an agreement, whether or not the patent is infringed, whether or not the patent is valid, whether or not the patent is unenforceable, is irrelevant. There's no requirement that a court actually look to determine any of those questions. You just look at the agreement, and you decide whether you think that the agreement on balance is more anti-competitive than pro-competitive, and therefore make a decision that way. Now, the Chief, and I'm not really paraphrasing here, said, good luck to district courts in trying to apply this standard. And I think that's almost a direct quote. There were only 3 justices in dissent because Justice Alito recused himself in this case. And I have a sneaking suspicion that Justice Kennedy went with the former liberal justices just because a 4-4 split would just get it back to the next term anyway. And so I think that if you look at it as jurisprudence, it's the problem with the decision is that it really, once again, is part of the retrenchment of patent law We're not yet at Justice Jackson's, the only valid patent is one Supreme Court hasn't got its hand on yet, but we're getting there. And I think that the idea that patents harm innovation is one that is clearly something that at least Justice Breyer believes, and I think some of his colleagues also believe as well. I know where it comes from, mostly guys on his side of the table, and the fact that we're going to take your cell phone away from you because of these patents. But the fact of the matter is that we are at a point now where I predict that we're not going to have a lot of these sorts of settlements anymore. And there's one other little glitch to this or loss to this. What people have started to do was not to settle for millions and millions of dollars, because that's the red flag in front of the ball. That raises these issues, even for people who otherwise don't have any skin in the game or don't have any particular looks one way or the other against them. You have the brand giving a generic $100 million to stay off the market for 5 years. It just doesn't look good. So what they're saying is, we'll make a deal. We will make you our authorized generic, or we will not bring our own authorized generic to market. And therefore, because the one thing in the system that the brand's always allowed to do is to sell their pill for less money. So if the generic comes on 180 days, one of the things that in that time that the brand can do is to make its own generic and start selling its pill at 80 cents on the dollar or 60 cents on the dollar. And it probably has deals at brand price already, so it still has the money it's making. It will make less money, but that seriously reduces the incentive for a generic to be the first filer in the first place. And so one of the things that the generics want is to not have the brands do that. And so part of the terms that the generic that the parties have come up with more recently than the last 5 years, is to do that. A promise not to be an authorized generic. And the FTC, even though the initial argument was that payment of money was the red flag and that this was anti-competitive and all of that, now anything of value is now the key word. And the agreement not to launch an authorized generic is now something of value. So I think it's the Effexor case is in the Third Circuit now. It may still be in the District Court in the Third Circuit, but the FTC has come in and said the fact that no money changed hands and that it was just this agreement for no authorized generic is something of value. And because it's something of value, it falls within the same scope of this raising antitrust scrutiny as paying money would do. So I do think that you're going to have pressure from both the FTC and others, and these different consumer and other groups, that every time these sort of settlement agreements are broached, you're going to have to worry about whether you're going to be in court over this in antitrust litigation. And frankly, at some point you start to do the numbers like, well, if we're going to do this, we'd much rather be doing Hatch-Waxman litigation with patent lawyers, not that they're better than antitrust lawyers, but rule of reason. The Chief's dissent is hysterical because he calls it the rather amorphous rule of reason. I think that for a patent lawyer anyway, it's a lot cleaner and more certain to make the argument in the patent law than to use some of the more subjective rule of reason sort of analyses that come up in antitrust law. And so I think that the likelihood of these settlements will go down, and the likelihood of authorized generics will go, or launching an authorized generic will go up, because brands still want to keep generics off the market. And if the way to do it is not to settle with them, but to launch an authorized generic and therefore disincentive them from doing it in the first place, that's what's going to happen. So this is one of those sort of congressional monsters. It's a bill that meant to do one thing, and now it's done a few other things. We'll see. But I think that the era of these settlement agreements is probably over. And now we do what we always do when the Supreme Court speaks. We have the great human experiment to see what happens in light of that, and whether, in fact, the impetus, the policy impetus for making the ruling in the first place, which is replete throughout the opinion. And if you listen to the oral argument, Justice Kagan and others, the consumer loses. It's the consumer who loses. It's these two companies conspiring against the consumer. Maybe the consumer wins, maybe they don't. But I do think that all I can say is we'll find out. So that's what's happening on my side of the equation. If you have nothing else, I guess we can take some questions. Sure.
You seem, your tenor is rather skeptical of the Supreme Court on these cases.
Generally, yeah.
But it seems like, your prediction of what happens, which is that the lead manufacturer ends up selling some authorized generics. Isn't that exactly an outcome that FTC would like?
The problem is that it probably, they would like it, except if.
Cheaper drugs, right?
Well, no, that's right, except if that practice would reduce the size of the pot of gold at the end of the rainbow enough so that you're not going to get the same frequency of generic challenges. That you're right. If that was what would happen, okay, that would be fine. You know, one other thing that I forgot to mention is that was important in the district court and the appellate court cases is that there's the blood in the water aspect here. That you can have other people challenging the patents besides the first filer. And the law was changed that the first filer doesn't actually enter the market because of this agreement. They don't act as a block for everybody else. Okay, and that was also changed in the law. So one of the appellate courts specifically said, you know, this is not a case where making one settlement agreement makes all the trouble go away. You're in fact going to have other people who will see that if they see that as a weakness in the patents, they'll be motivated for them to go on the market. So yeah, we might get cheaper drugs if the pattern holds that we get the authorized generics, but I'm not going to have an authorized generic unless I have a serious generic challenger. And if the frequency of that goes down because there's no gold at the end of the rainbow, then you know, again, we're looking globally. And I'm sure there are going to be instances where the consumer benefits, but if you look at the entire system, I'm not sure that's the case. It may be. We don't know, I guess is my point.
Yeah.
Yeah.
So thanks both of you guys for coming here. There were a few words that both of you said in common, but
Thank you for being
these are like two different worlds of two different marketplaces. But right, you're both here at the table because both of them have this core of patents that are at stake. Right, and kind of the traditional patent law was that we had the patent law, and whatever industry you're in, it applies to your industry. You know, is the marketplace and the demands, the public interest demand and the demands of the companies involved so great at this point that really we should be open and welcoming to having specific case law and statutory development for pharmaceutical industry that is just, and also specific development in the standard settings or electronics industry, just because the way patents are used is so different, that we ought to just go ahead and admit that they're different and treat them totally different in the law.
Yeah, so this is definitely an idea that's been floated, and we do have a unitary patent system, right? And from the earliest days, it covered patent medicines and railroad engines and you know, all different types of inventions. But yeah, lots of so Mark Lemley and Dan Burke in their book The Patent Crisis make this suggestion that yeah, maybe these industries are pretty, because they are clearly different. I mean, with pharmaceuticals, it is often one patent that covers an active ingredient, you know, molecule. It's not 250,000 patents or anything. Even it's like a radical difference in the way that you have to just analyze these problems is completely different. You know, 2.5% royalty for the one patent that covers the drug is actually a pretty low royalty. It's reasonable. It's on the low side. You know, obviously, when you start to multiply that, we have this patent stacking issue in electronics and telecom that's just huge that nobody really knows how to deal with in a very effective way. And so Lemley and Burke's proposal is, yeah, so Congress isn't going to fix this anytime soon. The PTO is open though this week, as you know, the one agency is still working.
We are lucky. Jim and I were just talking that it's lucky that we didn't invite anyone from the patent office.
They could come.
Because they wouldn't have been.
You know, it's not something we have, other systems haven't dealt with. Germany had a utility model for very many years where it's very simple, they still do, where it's very simple, they only examine for novelty, and it's a shorter term of the patent, which I think would line up with the obsolescence timelines and some of the double E stuff. But the other difference really is let's take omeprazole and Prevacid. Okay, I don't remember the name of the drug, but Prilosec and Prevacid to use the brand names. They both treat heartburn. They both treat the acid reflux disease, and they both act by inhibiting the acid production in the stomach. totally independently patentable, totally independently regulatable, totally independently marketable. And they don't do the same thing, but the molecules are different. And so it's the exact opposite. You don't have one person with a patent that has the applet for whatever it is this thing does, and then you control the market because somebody comes up with a competing molecule or competing formulation, and so you do have that sort of competition, which you don't get. You don't have to all sing from the same hymn book if you want to get a drug that will treat the same disease. So there's lots of reasons to say trying to shoehorn everybody into the same patent law produces things like the AA, where you have, and its predecessors, where you have both, bio and pharma and the IT industry lobbying Congress for different things, and at the end of the day you get, what I think even Dennis She would admit is a kind of a watered down bill that doesn't have half the things that most of the proponents wanted in the first place when we started writing about it 5 or 7 years ago. And so, okay, we have what we have, but I think it would take that kind of a change to say we're going to start treating these things differently at the applicant's impetus. So you want to have somebody who has a standard-setting patent to say, this standard is going to really only benefit me for 5 or 6 years or whatever it is, and so I don't need a patent for 17 years. And nobody's going to challenge it if we have FRAND and all of that, so why don't we just get it and be done with it, okay? And that could in fact work, but the fact is Congress going to get to anything, at least while President Obama is still president? Probably not. Okay, it's just not in the cards. So,
and part of the problem is also that the patents are qualitatively different. Right? I mean, the reason, you're absolutely right. You can have 2 completely different drugs that are each covered by one patent. They do the same thing. They have the same, biological effect. Because you're claiming the molecule.
That's right. Totally different.
Whereas with patents that cover software, for example, there's this famous debate. It's the result that's covered, right? It's not the actual software code, not the molecule, right, that's behind the software, but the result. So, making a screen bigger by double tapping on it or by expanding your fingers, to zoom in on a screen. That's what's covered by the patent, not the lines of code that make it happen, because unlike the molecules, you can program that code in 1,000 different ways. And the view is that the actual programming of the code isn't very important. And if you patented that would be useless and worthless, because it would take, any high school student these days could just program around it. Copyright is there to protect the code. Lots of critiques of that as well. That is not a perfect system. We don't have a perfect way of protecting software, and there have been a lot of proposals around it, but it's part of the problem.
yes.
So the inventions clause seems like, by way of history, there's like almost nothing in the Federalist Papers on it, because I think everybody at that time, I go back that far, agreed pretty good idea for the country to be able to enfranchise what I think are individuals. So it's kind of an embedded civil right because it's one who invents, right?
Right.
And now I'm looking at the legislative and litigation histories, and it seems like we're trying to subordinate that clause to the Commerce Clause. I'd be interested in your thoughts on that.
Well,
Whether you think that that's an argument that needs to be restated at some point to make sure that the inherent rights to the individual or the person under the Constitution weigh at some equality, because it is a separate clause.
yeah, I think that assessment, though, then plays into the Supreme Court's obsession with monopoly, and here's why. The reason I think the founders thought that patents were a good idea was not for the individual. It was for the public. And the reason for that is that patents promote disclosure of things that, as they get more complicated, are easier to hide the ball. So if it's a plow, then okay, I get it. You can copy the plow, and that's an individual right. But there's lots of things in my world that if we decided no patents, it would survive because we would just fuzz everything up and make it really hard to reverse engineer. And so I think that we can think of it as an embedded civil right. I think of it more as a power of Congress meant to promote progress by really incentivizing disclosure and disincentivizing people keeping things as a trade secret. And one of the things one of the many criticisms I have of the AIA is by the prior user rights sort of cuts against that, because it enables you to hide things, commercialize them, benefit from them, and not suffer the risk that somebody will patent it out from under you and therefore prevent you from doing it, which was a serious disincentive for people doing exactly that. And so I think that we're better off, in my view, thinking about it in terms of that promoting disclosure, because it changes the way we think about the value of patents. Not to be so obsessed with it as what it grants the inventor, but what does it grant the rest of us?
Yeah, I would agree with that, right? I mean, remember where the patent and copyright clause is placed. It's Article 1, Section 8, Clause 8. It's one of the enumerated powers of Congress, along with the power to, tax, declare war, create a postal service, and so forth. And the preface is in order to promote the progress of science and the useful arts, or whatever.
Right, yeah, that's it.
It's a social, it is sort of a social welfare, social good clause, I think, as opposed to an individual right. I mean, it's, it wasn't in the Bill of Rights, wasn't, I don't think, and having had the opportunity to look at the Federalist Papers recently for something else, I don't think it was viewed really as an individual right, so much as Justice Kevin said, something like an army, or a navy, or to benefit the society overall.
Are you sure? I mean, it was a property right that was being established. You're right. To incentivize, look, if you're going to work hard to make things, we'll give you a monopoly because we'll be better off by having it. But at some point, the monopoly is going to happen.
Right.
It'll become part of basically the public domain. It's a pretty good solution and was not terribly argued with.
Oh, no, I think I agree with
The
that.
government.
There's actually a very good book called Common as Air, and the author gets everything else totally wrong. But he gets that, it's one of these, patents are bad sort of work. But he gets that, he by reciting what said in the Federalist Papers, what Franklin said, and what Jefferson said, by the source, if you read it with the right perspective, you can see what they meant. And a lot of remember, the patent monopoly in England was the king gave you the right to be the person who reports what Parliament said, or to make French parasols, or whatever it is. It was a totally the opposite of how we use the term now. And so that's what I think the colonists didn't want to happen.
Exactly.
Okay? And so I think that public benefit was, I think, their impetus, even if they didn't think it was necessary to expound upon it, extensively. I think that was why they did it.
I mean, the word egalitarian system.
Well, yeah.
And there's
You're
a
right.
lot of talk about the property aspect of that. I think 1789 is too early to, impute that property characteristic to that thing. I think the thinking really was these were sort of royal rights that were granted, sort of an entitlement versus property. I think that developed later. But anyway.
On that note, I want to thank our panelists for bringing